It's a driver's nightmare for his or her vehicle to have a major mechanical failure while on the road. As most drivers rely on skilled professionals for their vehicle's maintenance, who should be financially responsible for a third party's injuries caused by such a mechanical failure? This question of tort liability is what we explore in Maloney v. Rath. Ramona Rath was pulling up to a stoplight when her vehicle's brakes failed, causing her to collide with Kathleen Maloney's vehicle, which was already stopped at the light. Prior to the accident, Rath had no reason to suspect that her brakes were faulty. She had hired a local mechanic to overhaul her brakes only 3 months beforehand. And approximately 2 weeks before the collision with Maloney, the same mechanic inspected Rath's vehicle for damage after a different collision, failing to identify any issues with the brakes. Evidence later showed that the brake failure was caused by the mechanic's faulty installation of a hydraulic hose when performing the brake overhaul. Maloney filed a negligence suit against Rath, seeking to recover damages for bodily injury and property damage. Under California law, the failure to maintain properly functioning brakes gave rise to a presumption that a driver was negligent. A driver could rebut that presumption by showing that he or she performed the same reasonable maintenance that a person of ordinary prudence would perform. The trial court found in favor of Rath, holding that she sufficiently rebutted the presumption of negligence by showing that she had taken appropriate measures to maintain her vehicle's brakes and had no reason to suspect that they were faulty. The appellate court affirmed, and Maloney appealed to the California Supreme Court.